It is our duty to fight for our freedom.
We will not make excuses. We will make changes.
It is our duty to
It is our duty to must love and support. We must love.
Does the mayor still plan to spend this money in the same way following this announcement? And if so, why does he think he has the authority?
We have nothing to lose.
I've been here every day.
We have nothing to lose but our chains.
But our chains.
Versus Brice Rhodes, 16 CR 1891. Here on this one for among a couple of other things, the competency hearing. And how would you like to proceed generally? I think that the Commonwealth will call state expert first. Go ahead, Mr. Armstrong.
Your Honor, the Commonwealth calls Veteran of the Hour.
Judge, a couple of matters, just, one is that, are we set up on Zoom? We had previously agreed that some of the witnesses would testify by Zoom. I just wanted to make sure that we were.
I am. I have the TV off for now. I didn't want any, if anybody makes any noise on Zoom, I didn't want it to be heard in the courtroom. But when it's time for that, I'll turn that on.
Okay. Judge, also, we did want to renew our motion that we made on Monday to seal this proceeding and exclude the public and the press from these proceedings.
Is there any new basis for that?
No, Judge, the basis is the same that we briefed and argued on Monday.
All right, the ruling will be the same as well. Anything else?
No.
Thank you, Mr. Cooper. Dr. Allen, good morning. Raise your right hand, please. Please swear to tell the truth and the whole truth. Thank you. You may proceed.
Please state your name.
Timothy Allen.
Where do you work?
I'm a staff psychiatrist at Kentucky Correctional Psychiatric Center.
How long have you been there?
It'll be 20 years this summer.
And what's your educational background and work history background?
Sure. So, graduated from the University of Louisville in 1994, then went to UK College of Medicine. Graduated in 1998 with my medical degree and did a 4-year psychiatry residency in UK, and completing that in 2002, and then a forensic psychiatry fellowship at Tulane University in New Orleans in 2003. I'm board certified by the American Board of Psychiatry and Neurology, general psychiatry, forensic psychiatry, and brain injury medicine. Been licensed in the States since 1999. I've been employed at KCPC for almost 20 years and a faculty member at UK that long.
And have you ever done a competency evaluation before?
Yes, ma'am. I've done about over 2,000 competency evaluations for the state. Probably testified several hundred times.
Thank you. Were you appointed by the court to evaluate the defendant Brice Rhodes?
I was.
Where did this evaluation occur?
At KCPC in the branch.
And when did it occur?
So the competency evaluation occurred, was an inpatient in our facility from November 21st to December 8th of 2022.
Had you previously evaluated Mr. Rhodes?
I had, pardon me, not for competency, but for another, for criminal responsibility. That was the order at that time. And that was in July and August of 2019. So it had been 2.5 years.
And was that also an inpatient evaluation?
It was.
And did you have access to all those records still to this day?
Absolutely.
Okay. When the defendant was at KCPC this time, how long did you spend with him?
I spent about, total time over the 3 weeks he was there is probably an hour and a half face-to-face. That's several short visits and then one longer visit. And then I observed him occasionally, at other times interacting with peers, but as far as sitting and talking to him, probably about 90 minutes total.
Did other members of your staff spend time with him?
Absolutely. So he spent combined 2 or 3 hours at least with a social worker. He had an evaluating social worker interview that was pretty brief because he'd been incarcerated the entire time. It was probably an hour or more the first time he was with us, probably 20 minutes or less the second time. He underwent some psychological testing with our director of psychology, and that's several hours, 3 or 4 hours of testing. I think that was observed by the defense expert in that case. And then, of course, patients at KCPC are essentially observed 24 hours a day by nursing staff and by correctional staff, and they write notes every shift, and then we discuss these. So I, as a team leader of this evaluation, rely on all those other professionals' observations when I'm not there.
Did you review any medical records related to the defendant?
So yes, we had a few, and well, let me flip back through everything. So obviously we had I had all the information from his previous admission back in 2019, and then the records I had mostly from that point, or even at that point, were legal records. So he's never been in a psychiatric hospital before KCPC, so there's no records there. His mother reported that he was treated with Adderall for ADHD as a child, but we don't know exactly where that came from. We don't have a record of that. Don't know if he's a family doctor or psychiatrist. And he's been medically healthy most of his life, so he doesn't really have a lot in the way of medical records.
So is there anything medically speaking that would give you concern about competency?
No.
Let's just go through the report pretty much how it is written. Did you or anybody on your staff notice any auditory or visual hallucinations? Or did he report anything like that?
No, he reported none, and this is something we look for because we do have individuals with severe mental illness who do not want to reveal it to us. And so we observe people to see if that's the case. There was no indication with Mr. Rhodes that he's having hallucinations or suffering from significant symptoms of mental illness.
And back in 2019, when he was there for that evaluation, was there an issue with him reporting such events?
Yes, he reported hearing whispers, sometimes of his name. He reported seeing sort of shadows or visions in the sort of corner of his eye that usually at night. He sort of relinquished those and didn't really report them at all this second time. And so at no time in either admission did we observe him like responding to those kind of hallucinations, or was there really any concern that he was suffering from severe mental illness? As you might know, at KCPC, that's a common problem, and it's something we treat regularly, and if we had any concern, we would have. But those medications have side effects, so we only treat them when we really believe they're apparent, and that was not the case.
And is it true that that was not the case in 2019 either?
Correct.
Did you see any evidence of cognitive impairments?
No, Mr. Rhodes is articulate. He always sort of understood his surroundings, behaved appropriately, followed rules generally, especially in this 2022 admission. He had no disciplinary problems. He knew what to do. At our facility, you have to do your own laundry. You have to line up at the right times. You have to, understand the rules. We do have individuals who have cognitive impairments that we need to give extra help to, and that's clearly not the case with Mr. Rhodes. He was intelligent enough and aware enough of circumstances and what was going on that he didn't need that kind of special assistance.
What was his attitude like towards staff and peers?
So again, in 2022, polite, answered questions asked to him, participated in testing, pretty much did everything we asked of him. No disciplinary problems in 2022 at all.
At some point, did he report some symptoms of a medical issue?
Well, two things. One, he did, we treated him for folliculitis, an infection of hair follicles, with a topical antibiotic and then an oral antibiotic. So that's the only physical issue. That's obviously annoying for him, but pretty minor in the big scheme of things. But the psychiatric treatment we provided was, he reported some anxiety. He's under a lot of stress. He's been locked up for, I think, we're going on 7 years. And as trials approaching, all those sorts of things, I believe that was a legitimate complaint. We treated him with a medication called hydroxyzine, which is a mild anxiety medication. He reported benefit from it, so we continued it.
And does anything about that anxiety relate to his competencies?
I don't think so. I don't think he was severe enough to distract him, to make him unable to pay attention or to affect him in any dramatic way.
Can talk about the psychological testing of stuff?
Be happy to. Obviously whenever pretty much everybody that comes to KCPC, we try to do some psychological testing to look at one or two things, and in this case, three actually. So the first thing we're trying to assess is basic cognitive ability. And so, we boil that down sometimes to IQ. But really cognitive ability includes more than that. But that's kind of where we start. And then we're also looking at, we administer an assessment of psychological functioning to make sure we're not missing anything in our clinical interviews. And then thirdly, especially in a case of this severity, we'll try to do an adaptive functioning assessment that looks at issues that can be raised in Atkins cases where we want more than just a test number, we want to see how they're really doing in the real world. So the results of those tests specifically, we gave 3 tests of effort, because whenever you give somebody a cognitive test, you've got to make sure they're giving you good effort. If I ask you what is 2 plus 2 and you say 5, that counts wrong, that would make you look very impaired. You have to choose to correct the right, or say the right answer. So in these validity tests, he passed 1 and failed 2. So that suggests variable effort. So it's not that unusual for that to occur, but we just have to take it into account as we look at the scores we got otherwise. That sometimes he was doing a little better than others and may not have been as fully focused and eager to do his best. So we gave a reading test. He had a 9.5 grade equivalent. That's pretty consistent with his high school education. I think he has a 10th grade education. Never got a GED, so that's pretty consistent. We gave a test called the Color Trails test, which is something that looks at attention and motor speed and your ability to shift kind of sets or multitask. And he had an average score on the first part. He had a score that's like 1% below the cutoff for average, considered low average on the second, but these are not impaired scores. Again, not too shocking and pretty consistent with his abilities. On the Western Adult Intelligence Scale, which is the gold standard IQ test, his full scale IQ is 73. Now, when we dig into some of the components of that, we see his verbal comprehension, which is what we see when we speak to somebody, is 83. So that's actually low average, and that's pretty consistent with his academic history and kind of his functioning. Maybe a little suppressed because we know he didn't give us full effort, but somewhere in the ballpark. And then otherwise we see his other scores kind of falling in the borderline range on the IQ components, working memory, processing speed. Again, we have to take these scores with a grain of salt because he failed 2 out of 3 effort tests, so these may not be his best scores. On his best day, he might be several points higher than this. And then we give the MMPI, which is that psychological survey I talked about. It's sort of the gold standard test. It has its own validity scales, which is really nice. So if somebody's trying to exaggerate mental illness, it'll catch it. If they try to minimize mental illness, it'll catch it. And if they're confused about the questions, like they're written in a too complex manner, they're written about a 6th grade level, we'll catch that due to inconsistency. Well, what we saw in this case is he over-reported psychological symptoms. He reported infrequent psychotic problems and other psychological symptoms that, per the authors of the test, not my interpretation or Dr. Williams, but the authors of the test say it's invalid. So that meant that we couldn't really use those clinical scales to determine whether he's suffering from mental illness. So we have to rely on our clinical assessment. And then finally, we did a test we call the ABAS for short, which is an adaptive functioning test. It's a questionnaire, really, and we try to administer this to somebody that knows the person very well. In this case, Dr. Williams interviewed Ms. Rhodes' mother. Now, this is, again, a tool that we look at that is used out in the community, for instance, to see what kind of level of care somebody needs. Do they need to be in a group home? Do they need to be in a hospital? Do they need to be in supervised living? So the information gained has to be given truthfully and honestly for it to give a valid response. There's no kind of effort measured to this. His mother reported that his functioning was so low that he would have been at the bottom 0.1 percentile of functioning, which isn't really consistent with the way he acts. I mean, this is a guy who can take care of himself from everything we've seen. And so unfortunately, I don't think that was a valid response. And unfortunately, there's no similar test or survey that gives us would do any better. This is the best available, and it's imperfect. So that really sums up the testing, but just to kind of bring it all to one point, we saw sort of low average intellectual functioning, which I think, if he gave his best effort, may have actually been higher.
So on the test where you all interviewed his mother, are you asking her questions about like, can he do his own laundry, those sorts of things?
Exactly, yeah, there's a whole list of those kind of questions, about driving, about caring for yourself, about, doing chores, about independent functioning. And so she suggested his function was so low that he wouldn't be able to live on his own, that he would need essentially 24-hour supervision, and that's clearly not the case in his abilities.
And did you all in fact observe him doing his own laundry?
Yes, and and feeding himself and filling out his canteen lists and going to recreation and participating in activities on his own without instruction. I mean, he can function at least at a low average level.
Moving on to were there any psychiatric diagnoses at the end of this?
So I gave 3. One is antisocial personality disorder, and that is somebody who it's not a mental illness. It's a personality characteristic that is a lifelong maladaptive personality style in which somebody consists repeatedly having negative interactions with the law, with rule breaking, with difficulty fitting in. We see this back to his kind of behavioral problems in childhood and really through adulthood. So it's been consistent and important. So I thought he fits that. I diagnosed him with an adjustment disorder with anxiety. As I mentioned, we treated the anxiety. I think he's under a lot of stress. Understandably, this is a pretty common thing for somebody who's dealing with what he's dealing with. And then thirdly, with a polysubstance use disorder, which is primarily cannabis is what he's admitted to as his substance of choice. But there's at least some reports of other drugs at different times. And then that was in remission because there's very little, or I think no access to those drugs, obviously KCPC, and limited, if any, at LNDB.
Did you notice a difference in his behavior between the 2019 evaluation and the current evaluation?
Yes, in 2019, we talked about the hallucinations he reported, and he claimed that sometimes to have a very severe memory deficit, that he did not remember anything about his childhood, did not remember anything about his incarceration, did not remember why he was arrested, did not remember essentially anything before the day when he's being interviewed. And that's not really credible. That's not the way even people with Alzheimer's dementia would act. So, but in 2022, he did none of those things. He recalled why he was here. He recalled his prior admission to KCPC. He recalled certainly the most serious charges and the issues going on. So he kind of gave up on those complaints. And then also he did not complain of the hallucinations, which were kind of vague in 2019, but they just weren't present at all in 2022.
Can you describe to the court how you conduct a competency to stand trial assessment?
So there's several steps. One is looking at collateral information. So that can be police reports, criminal investigations. Sometimes there's interviews of witnesses and all that sort of thing that I look at. In this case, it's mostly just the criminal investigation and police reports. And then secondly, observation over an extended period of time. In this case, we really had 2 months, broken up over 3 years, of just how somebody functions. And then there's the assessment of their mental illness, just generally whether they're so severely depressed or schizophrenic or cognitively impaired, so the testing and all those things. And then finally we end up with sort of a forensic interview. And in that interview I start out with open-ended questions when possible, and then sometimes I have to get very specific about asking details about what the individual understands about the charges they're facing and the court process they're up against. And so when I entered that interview with Mr. Rhodes, he was generally cooperative, answered a lot of my questions. He remembered our previous discussion 2.5 years earlier and knew details about my conclusions. He recalled, it appeared to me he'd read my report, not just my test, or I hadn't testified about it because it was potentially a trial issue. And so he knew a lot of that detail, which is an indicator of somebody's understanding. And then, of course, I went into detail about his knowledge of who his attorneys were, what their purpose was, the role of prosecutor and judge. He answered most of the questions, not all of them. Sometimes he's a little coy or didn't want to respond specifically to questions, but generally, I believed that he provided enough information to reveal that he had a general understanding of the cases against him, a general understanding of the proceedings in the courtroom, the roles of the individuals, the role of his attorneys to provide him for defense, that he chose to use them, but he kind of indicated he didn't really want to and thought he could defend himself. And generally knew some, he claimed not to really know much about specific paperwork or evidence in the case, although, like I said, I know he had clearly was at least briefed on my report from a few years earlier. He talked about watching the O.J. Simpson trial, kind of knowing a little bit about that, and he knew the attorneys, two of the attorneys in that case, and so he was able to make relevant references to kind of the process he's involved in, and also expressed his frustration with the legal process, and he felt as a defendant that maybe he's not getting treated fairly, that everyone's employed by the state, so there's conflicts of interest. He didn't use that term, but he certainly insinuated that concern. He was concerned that the previous court, the previous judge was racist and would be against him. So he expressed those fairly rational statements, even whether the facts back that up is another issue, but things that I hear other defendants say rationally and concerned, made reasonable concerns about whether he can get a fair trial. I mean, as we sit here today, and there's a lot of publicity about this case that brings up concerns, and so he was able to discuss those and express his frustration with the process thus far. So putting all of those things together, I think I had a lot of information in this case. I think I had, both from observation, the 2 hospitalizations, and the collateral information, to make a determination, and felt that ultimately he did meet the statutory criteria, that he could appreciate the nature and consequences of the proceedings, that he could participate rationally in his own defense.
And do you think, based on how he was able to take his ideas and communicate them to you, that should he choose to testify, he would be able to coherently testify to a jury?
Yes, I think he's shown to me that, and this is not, that he can tell the truth when it helps him. He can tell things that probably weren't true about his memory deficits, about the hallucinations in 2019, but consistently do those. So it was my knowledge of mental illness that made it obvious that wasn't the case, not necessarily that he couldn't maintain a story. So whether truthful or not, he's spoken ways that benefited him. And that's not necessarily, I don't know what I'd do in that situation, but it shows his cognitive ability to do so if necessary, to protect himself, to say, to speak in rational ways, both for his own benefit.
And if he chooses to assist his attorneys, do you believe that he'd be able to assist them in preparing a defense and discussing legal strategy?
Yes, ma'am.
And do you think that he understands the roles of the people in the courtroom?
Yes.
Do you think he understands the cause and effect of the charges against him?
Yes.
And do you think he understands the consequences of his actions?
Yes.
And you said before you believe he's competent to stand trial. Is that based on reasonable medical and scientific probability?
It is.
I have no further questions. Your Honor, the Commonwealth is going to enter the report from Dr. Allen into the record.
So there's no objection to that?
Judge, we object on the same grounds that we gave in our hearing on Monday.
All right, that will be admitted under seal.
Excuse me. I'd just like to note for the record an objection to the sealing. I understand it's.
Of the competency evaluation itself?
Yes, Your Honor.
We can discuss that later. All right, Vice Rhodes.
Good morning, Dr. Allen.
Good morning.
Doctor, I want to take you back through some of the things you testified about and some of the other matters that are contained in your evaluations. You have both the reports, do you?
I do.
Okay. Doctor, you would agree that someone suffering from paranoia, if it was significant enough, could be found incompetent to stand trial?
I'm sure I've found that before, yes, sir.
Okay. And someone's paranoia affects them in a lot of different ways, right? It could affect their competency to stand trial, right? It could also affect their ability to participate in an evaluation.
Possibly.
It could affect their ability to take the tests that you've been talking about.
Or, yeah, their willingness to do so if they're fearful for some reason.
Based on your time and your evaluation, Mr. Rhodes demonstrated several aspects of paranoia, correct?
I guess you could say that. I mean, he certainly had some frustration with the legal process, felt that he wasn't necessarily getting a fair treatment by the process, so you know, that could be a component of paranoia.
Well, one thing he indicated, for example, and I can turn your attention to the first evaluation. On page 7, he indicated that, and I'm not trying to rush you, are you?
No, I'm ready.
On page 7, he indicated that one of his habits was to lay out traps in the room.
Right.
This is a secure room, a locked room, correct?
Yeah, it's essentially a jail cell where he's by himself.
And nonetheless, he indicated that it was a standard practice that he had to lay out traps.
He did say that.
Okay. And he indicated that the reason he would do that is to know if other people had come into the room. True.
Yes.
If other people had touched him or his things or been there.
Yes.
He had multiple things that he would lay out, sometimes larger objects, sometimes smaller objects, to see if it had been touched or in any way manipulated, right?
Yes.
He also indicated that at times he felt there had been someone in the room, specifically he referred to the movement of his silk.
That's true.
Okay. That would be a paranoid thing, wouldn't it, Judge? Excuse me, Doctor.
Yes.
Okay. You didn't bring that up when you were testifying a minute ago.
Yeah, I didn't. Obviously, yeah. We talked about the hallucinations. I did not bring that up. That's all. Obviously, it's in my report. That's true.
All right. Additionally, when you're talking about the hallucinations, let's talk about that with a little bit more specificity. He talked about hearing voices.
Yes.
And he talked about seeing things. He referred to them as shadows.
Yes.
Right. As a doctor, you would refer to them as hallucinations.
Yes. So possibly hallucinations. The other term we'll sometimes use are illusions, which are when you see something real but you misinterpret what it is. So it kind of depends on the situation, but he sort of said that you'd see him, not directly in full form, but sort of in the corner of his eye, or he's looking away, his peripheral vision. So it's somewhere in that spectrum.
Additionally, he indicated, and I can refer you to the second evaluation, in multiple places he talked about how he believed people were attempting to poison him.
He did say that on a couple occasions, yes, sir.
And that is a classic example of a paranoid belief.
I'd agree with that.
You've encountered that particular paranoid belief in other cases.
Absolutely.
Okay. And he did indicate that to you specifically on page 6. He said that the prosecutor was trying to poison him.
Yes, I think so. Yes.
And that the prosecutor was in a conspiracy with other people for him to be poisoned.
Yes, and I think jail staff.
Obviously, you don't believe that was occurring.
I do not.
His belief that people were trying to poison him, and in fact, there was a conspiracy of multiple people to try and poison him, is a classic paranoid belief.
Right, if he truly believes that, and if he acted in that fashion, yes.
thing from the second evaluation, he indicated that he wakes up during the night in order to try and keep people from harming him.
Right.
That is also another classic paranoid belief.
It is, and it's also, I mean, when you're in a group dorm and they're, you know, in a jail, that can be a protective mechanism, but when you're locked in your own room, that obviously wouldn't be necessary.
And were you aware that he also is in a single cell in the Louisville jail?
I know he has been a lot of the time. I don't know if it's been the entire 7 years, but I know that's been the case a lot of his incarceration.
So if someone had for years been in an isolation cell, they're feeling that they had to wake up repeatedly during the night to see if someone was there, that would be outside the norm.
It would.
In fact, that would indicate paranoia on the part of the individual.
Yes.
Another, I know I'm jumping back and forth,
Sorry.
back in the first evaluation on page 7, he indicated that the skin condition, you referenced it in your...
Yeah, folliculitis.
Yes. I'm not going to try and pronounce it because I'll mess it up. He indicated that he believed it bled or did not bleed depending upon his belief and prayers.
Yes.
That he indicated to you or to the staff that if he prayed, then it did not bleed, and if he failed to pray, it would then bleed.
He reported that he's.
That is not a rational belief this time.
I don't believe it is.
You indicated to, in your testimony a minute ago, some of the results of testing. You're not a psychologist. You didn't actually administer most of the tests you're talking about, right?
That's correct.
Okay. So I'm going to take one, for example, the ABAS, the ABAS.
Yeah.
That test, you indicated he scored very low.
Yes.
You also said that in a structured prison environment, you saw him able to follow some of the rules.
Yes.
But that's not what the ABAS test is about.
Correct. No, this is trying to assess like real life situations. So yeah, they're not apples to apples comparisons. I agree.
Okay. So the fact that he may have had the ability to follow some of the rules of KCPC does not in and of itself undermine the result of the ABAS test.
I think they're too divergent. I think he could have real functional impairments or weaknesses that his mother observed, but he wouldn't have been the 0.1 percentile. I don't think people that are that low are usually severely cognitively impaired or severely mentally ill, such that they have trouble with kind of reality. So I think that score's too low, but what's the actual score? I don't really know. It could be below average, but I don't think we have an accurate measure.
And you indicated that he did in fact score in the normal range for some of the lingering tests. I'm going to use that term.
Yeah, one out of 3 he passed, and then 2 out of 3 he failed.
And if someone was suffering from paranoia that affected their ability to participate in those tests, that could also be an explanation.
Well, yeah, if somebody is fearful while they're taking these tests, they may intentionally do poorly because they think it helps them in some manner or whatever. So that's a possibility. We cannot determine why he would have given poor effort on those 2 tests. The motivation is something I can't say. I can tell you that paranoia doesn't cause you to have memory deficit, but it may impair or impact how you decide to take the test because you feel that Paranoia, the basis of that is fear. And so if you're fearful, you may act in ways that the rest of us think are irrational.
As you've already testified about with some of his other symptoms.
Yes, again, if you believe all those symptoms to be accurate, to be reported accurately, and him behaving in response to those beliefs, that's a concern, I think.
Let's talk about page 6 of your second evaluation. And I guess maybe at the very end of page 5 as well. Mr. Rhodes indicated that, in fact, from his point of view, he has no attorneys.
Right.
I think that may be literally a quote.
Yeah, he said, "I'm my own attorney," was his word.
He said he has no contact with his attorneys.
Right.
He said he doesn't speak to his attorneys.
He did.
He said he doesn't think that we are his attorneys.
Right. He doesn't want attorneys. He thinks he can defend himself. He thinks he won't be represented appropriately.
He indicated that he believed that there was a conspiracy against him. I think he used the words big scheme.
Yes.
Those are all indications, or those would be consistent with someone who's paranoid as well, wouldn't they, Doctor?
They could be.
Is that, yeah?
Yeah, they could be, yes.
Even your conclusion regarding his competency in your report had a reservation, didn't it, Doctor?
I don't know, what are you referring to?
Well, I'll tell you. On page 7, you indicated that you thought he could participate rationally, and then you added something that I've never seen. You may have, but I haven't, on a competency evaluation. You said, when he chooses to do so. When he chooses to do so makes it sound like you're indicating someone who is completely healthy. But that's not our situation here. When you're talking about that, couldn't paranoia and a condition like that be the reason someone is unable to be competent to stand trial?
Certainly it is, and then I don't think it's really up their choosing if they're so mentally ill that they don't understand the circumstances they're under, or they have, due to mental illness, false beliefs about, the courtroom and the process. Yes, I agree that could bar competency, but then I don't think it's a choice. My opinion throughout this is that Mr. Rhodes, I know you pointed out some symptoms he's reported, but I don't believe that he has a true severe mental illness. I think some of these are legitimate concerns about racial issues in our justice system. And then some of them are exaggerations and fabrications by Mr. Rhodes. I do not believe he has severe mental illness. I don't believe he has paranoia based on mental illness.
But believing, in fact, that you're being poisoned, for example, and not just poisoned by one person, but poisoned by a conspiracy of people, that's an indication of mental illness.
Again, if you truly believe that, and if you behave in a way, I have certainly seen and have treated patients who quit eating for months, essentially, because they were afraid that their food was poisoned. I don't think that's been the case with Mr. Rhodes. So I don't think he's displayed the behaviors consistent with that, even though he's made some of these statements.
And if someone was so paranoid about the other members of or about the participants in the legal system, that they in fact refused to speak to their attorneys because they believed they were part of a conspiracy or a big scheme, that would be an aspect of paranoia.
It could be, yeah. Again, if it's born out of mental illness, yes. I mean, again, like I said, there are some legitimate concerns about racial equality in the justice system that I hear a lot of defendants talk about, and so that's an issue. It's a legitimate one. Then there's sometimes born out of mental illness, as you're referring to, paranoia about counsel, that can prevent competency.
Thank you, I have no further questions.
Just to be clear, are all these incidents cited by the defense counsel things that the defendant self-reported, or did you all ever see evidence that you could document that he was laying out traps, etc.?
I'm unaware of any observations by staff of any of the paranoid behavior described or responding to hallucinations, any of that. And as I mentioned, some people who are paranoid, who are psychotic, don't tell us about those things. So we do have to observe it, and that's a common issue that we deal with at KCPC. So, we didn't see him act paranoid towards peers. He interacted, he went to recreation, people surrounding him, not worried about people behind him. He ate the food at KCPC, was never concerned about that. To my knowledge, has never gone on a hunger strike or anything at the jail, even though he's expressed those concerns. So I don't think his behaviors have matched some of those reports, and so that's one of the main reasons I did not diagnose him with a major mental illness like schizophrenia or something that can cause paranoia. And then we don't have a history of any of this before this arrest, before this incarceration and this criminal prosecution. If he'd been at Central State 10 times in his life and been seen to be paranoid repeatedly, that's a whole different situation. We have none of that in this case.
Was there actually an incident in 2019 where you all were aware of a threat to his safety?
Absolutely. So there was a report of a verbal threat from an inmate at Luther Luckett where we share fencing. Basically, they're on the other side of a fence. There's one building that we share where patients in our facility and inmates there could interact. It's very rare. So we had to make sure that Mr. Rhodes wasn't exposed to those kind of areas. But we made Mr. Rhodes aware of that threat, so he was fully aware that individual was there and at least through rumor had made a threat. So he was aware of it. He was not particularly concerned, he said, and did not change his behavior as a result.
And was that a threat from the father of one of the victims in this case?
That's right.
Did anything about his reports on any of these potentially paranoid incidents cause you to question your assessment of his competency?
No. In the first hospitalization, we were, didn't know him and were open to consider these things, really looked at them and weighed all the evidence, because what we want to do if that's occurring is treat that person, because I see we have multiple roles at KCPC, and one is to treat people with mental illness to restore them to competency if possible. And so we would have treated him if we'd seen it and thought it was legitimate illness. And as I mentioned, his 2019 presentation, he presented many more symptoms than he did in 2022, which to me says and he never got treatment in the middle, so it's not like he had mental illness that got better. It's that he relinquished, gave up kind of claiming those things. And so I think we saw more of the real him in 2022. He still made a few statements, the tainting of food by the jail and that kind of thing in 2022, but most of those concerning things are in 2019, where I think was sort of figuring out the best way for him to maneuver this whole legal process.
Thank you. No further question.
Judge, brief.
You just indicated that part of the reason that you found him competent, part of the reason you didn't diagnose him with mental illness is because
You weren't aware of any history of diagnosis, right?
Well, to your point, no hospitalizations, but there had been a report by his mom that at some point he'd been diagnosed with maybe schizoaffective disorder, and he'd been treated at least some time with an antipsychotic medication that cracks up. We were never able to track that down. We were never able to find evidence from where that occurred, and we didn't have a description of symptoms consistent with that diagnosis. Mostly what was reported was, this is again in his adolescence, aggressive or behavioral problems. So So there was maybe a diagnosis out there, we have no documentation to support that.
So if you did have that documentation and you were able to examine the prior diagnosis and all of those records, that could have changed your conclusion.
It's possible.
The other thing you said stood in the way of you finding him incompetent and diagnosing him with a mental illness was you didn't see evidence of actions that supported the paranoia.
Right.
If you did have evidence of those things, that also might have changed your opinion regarding competency.
It's possible. Again, it depends on the context of those things, whether because, you know, the sort of elephant in the room is what degree of any of those behaviors or statements are fabricated for an advantage in the legal process. But we consider all of those things. We consider that they could be real. And if the more of those kind of behaviors that were evident, the more weight they would carry.
And in fact, they also could have resulted in diagnosis of a mental illness.
It's possible.
Thank you. I have no further questions.
All right, Dr. Allen, thank you for stepping down. Okay, everybody, let's take about a 5-minute break before we exit. the defense, your first witness.
Judge, you would call Dr. Sean Gardner. He is testifying by Zoom.
Dr. Gunk, are you able to hear me?
I am, Your Honor.
Okay, I didn't turn the volume up just a little bit. Yes, sir. I'm gonna move it to you just a little bit. It's gonna give us that feedback. Sorry. If it's too close to a mic, it'll do that. Oh, gosh. Yeah, I know, but then we had to hear it. We'll see. Oh, that's a good idea. You can tell me. Deputy, you want to say something? What you doing, buddy? Yeah. Stop. Stop. He's somewhere in the in between, we just need to get him up here. Okay, hopefully we'll start getting some feedback. Mr. Griffiths, actually, Dr. Alarcon, could you go ahead and say something else so I can see if we can hear you okay?
Sure, how does this sound to you?
I think that's fine. Can everybody hear okay? Okay. All right, go ahead, Mr. Griffiths.
Good morning, Doctor.
Good morning.
Just so you know, I can't always see you, so I'm gonna try and, Judge, what camera speed is gonna find so you can see me? It doesn't matter. I guess maybe it doesn't.
It's showing the whole program.
Okay. Doctor, could you identify yourself for the record, please?
Sure, my full name is Bhushan, Bhushan, as in Nancy. Last name is Agarkar, Agharkar. And I'm a medical doctor, not a psychiatrist.
And before we go further, Judge, did you swear?
Oh, no, we're not gonna thank you very much. Doctor, could you please raise your right hand? Swear to tell the truth and the whole truth?
Yes, I did.
Thank you, sorry, there's just a lot going on, trying to get another witness here. Go ahead.
Of course.
Could you briefly go through your educational history?
Sure. I got my undergraduate degree from Case Western Reserve University in Cleveland, Ohio. I then attended medical school in Syracuse, which is my hometown where I'm from. I graduated with my medical degree in 2000. I then went to Emory here in Atlanta, which is where I'm located now. I went to Emory for a 4-year residency in adult psychiatry. I was chief resident my final year. I did a 1-year fellowship in forensic psychiatry, also here at Emory. So that was 2005 that I finished everything, and then I've been in private practice since that time here in Atlanta.
And where are you licensed as a medical doctor, sir?
I'm licensed to practice in Georgia, California, Arizona, and Kentucky.
Have you testified as an expert in the state of Kentucky?
I have, yes.
And how many times have you testified as a psychiatric expert, would you say, in your career?
I've somewhat lost track of it. I think it's somewhere around 110 times. I've done probably over 1,500 evaluations, so I testify about 7% of the time.
All right. Were you retained to do an evaluation of Brice Rhodes? I was.
And can you explain to the court how that went?
Well, I flew there to the jail to see him on April 17th of 2019. As I approached his cell, he looked, he appeared to me to be paranoid. He basically essentially accused me of being an undercover cop. He said I was a police officer. I was sent there by his lawyers to trick him, and that he would not talk to me. And when I tried to explain who I was, that I was a doctor, that I had flown here specifically to see him, that I was, been asked by his lawyers to try to see if there's something I can do in the case. That's why I was there. He simply said, "I've got nothing to talk to you about. I'm not going to talk." And we essentially had that conversation through the cell door. He would not.
So you explained to him that you were actually there to help.
To essentially help, right? I mean, obviously it's not a treatment role, but if I'm hired by the defense, then clearly they're asking me that if I find something helpful, they may call me. And so I was trying to explain that. I said, I'm here at the behest of your lawyers, not the state, not somebody else. It's by your lawyers. So would you talk to me? And he wouldn't talk to me.
You said that he exhibited signs of paranoia. Can you be more specific so that everybody understands what you're talking about?
Well, some of this is just clinical judgment. I mean, I've dealt with many psychotic people in my career. He just had no rational reason. He wouldn't accept my explanation, and he simply held fast to a belief that I had to have been a police officer, and there was no other explanation for why I was there. He wouldn't even engage in a dialogue with me on it. To me, he appeared paranoid. He just simply said, I'm just not going to talk to you. I got nothing to say to you. So again, it was a very brief interaction, so certainly I'm not making a diagnosis based on that, but it to me appeared to be paranoid, and then in conjunction with what I've learned about his interactions with the defense counsel, it's consistent.
Did you attempt to show him any ID or anything like that?
I think I may have offered to say I could show you my medical license, but we never got to that point. So, and I don't believe that I did that, but this is 4 years ago now.
Sure. Did he have any specifics when he said he thought you were a police officer?
I think that he said something that I was from Indiana, and I don't know why. I've not spent a lot of time in Indiana, so I shouldn't be associated with Indiana. But I believe he said that I was an undercover police officer from Indiana.
In addition, both in preparing for that meeting and preparing for today, have you reviewed records of Mr. Rhodes?
Yes, I have.
And have some of those records been historic diagnoses, for example?
Yes, they were past evaluations that were done on Mr. Rhodes.
In any of those records, was he in fact diagnosed with a psychological condition or illness?
Yes, he was diagnosed with bipolar disorder. This is the date of the assessment was 2013. He was diagnosed with bipolar and with a rule out of schizoaffective disorder, bipolar type. A rule out means I don't have all the information for it, but this is what I'm considering and could be a possible diagnosis. He was also given several other provisional diagnoses, but again, the main point is that he was diagnosed with a major mental illness.
Doctor, can you tell us how bipolar disorder would affect someone's ability to be competent to stand trial?
Well, bipolar disorder is a disorder involving fluctuating mood states. So a person can be depressed for a long period of time. They can have manic episodes where they've got tons of energy, they're not sleeping, looking more irritable, expansive, distractible. So those kinds of symptoms can certainly impact somebody's competence. But also what happens in bipolar disorder, as well as schizoaffective disorder, is that people become psychotic, or that they have a psychotic illness, and they become paranoid. They're paranoid of people around them, they're not trusting, they believe there's a conspiracy against them,
persecutory beliefs, things like this. So there's a lot of overlap between those diagnoses of schizoaffective and bipolar disorder. Those would impact competency.
One moment, Doctor. So, given what you observed personally, do you believe that paranoia could be a byproduct of a mental condition or disease?
Yeah, based on the records I reviewed predating this offense, as well as the materials I reviewed involving the KCPC interviews, yes, I do believe that paranoia may be a symptom of an underlying serious mental illness, as opposed to volitional.
And you talked about how someone with bipolar disorder, how bipolar disorder could affect someone's competency to stand trial. How would paranoia itself, as a symptom, manifested symptom, how would that affect someone's ability to be competent to stand trial?
Well, it can certainly affect a rational understanding of the proceedings against you if you believe that there is a conspiracy against you, if you believe you're being persecuted for some other reason other than what they're charging you with. That's a potential possibility. I typically more see it with the rational assistance prompt, because if you don't trust your lawyers and you don't believe that they are who they say they are, you're not going to disclose things to them. You're not going to be honest or talk about ways in which you can defend yourself. So it's going to impact your defense. And I know things like where he has told KCPC that his strategy would be to, he's not talking about his legal strategy, but he would go off his dreams and visions. He thinks he's as good as Johnny Cochran and Robert Kardashian. This is what he told KCPC. That's problematic, given what else we know about Mr. Rhodes. I think that that's probably unlikely that he would be as good as them. But more importantly than that, I think he is not able to articulate a rational reason why he mistrusts his lawyers. And my understanding is he's been through several sets of lawyers now, all for similar types of reasons. And if you're paranoid about it, you're not going to be thinking rationally and making rational decisions. Your decisions in assisting counsel or even in legal strategy, if you're defending yourself, are going to be made from a position of mental illness, of brain impairment, of paranoia, as opposed to rationality. And that's the real problem.
And if in fact your decisions are being made in an irrational manner, like you were just describing, then at that point the person is not competent to stand trial?
In my opinion, that's correct.
Thank you. I have no further questions.
Thank you. Doctor, this diagnosis of bipolar disorder that you observed in, well, you didn't observe, you read about in an evaluation from 2013, correct?
That's correct.
Someone with bipolar disorder can be competent, right?
Certainly, yes.
And if he were displaying evidence of the bipolar disorder currently, that would have been picked up by Dr. Allen and the KCPC team, correct?
If he was manic, yes, I think they would pick that up. If he was depressed, maybe not. The mood states do fluctuate. But I will say, paranoia may not get picked up on because it's not going to have manifestations of like psychosis, where you hallucinate, things like that.
But at the current time, you would agree, based on your reading of Dr. Allen's report, that he was not exhibiting anything other than what has already been discussed about the paranoid issues.
Correct, based on his reports, yes.
What was the total time you spent with Brice Rhodes?
Oh, probably 5 minutes.
Okay. And the time that you spent with him where he did not want to talk to you, it could be a result of paranoia, but it's also consistent with someone who just doesn't like his attorneys and doesn't want to do what they told him, correct?
That's possible.
And it could be just somebody who was in a really bad mood that day for whatever reason and didn't want to talk to anyone, correct?
I mean, that's possible, but they don't usually accuse me of being a cop and won't take any explanation I have. That wasn't rational. But I understand what you're saying. Sure, people have refused to see me before, and I haven't thought they were paranoid. But in this case, it was different.
Thank you. No further questions.
I have one question. you ever speak with Dr. Allen or anyone else at KCPC?
I did not, I only read his reports and heard his testimony this morning.
Anything else? All right, thank you, Doctor. You're free to go.
Thank you.
Any other witnesses for the defense?
Yes, Judge, is the witness.
I don't know. Do we have any? There was a mistake and the court staff didn't realize he was here for this because we didn't know that he had been subpoenaed for this. So the statement was incorrect. It was in the night. So we gotta wait for him to be brought back here.
Judge, we'll call a different witness.
Okay, if you all do subpoena and then again, if you can give us a heads up so that we don't send them back thinking they were wrongly sent here, that'd be great. Go ahead.
Judge, we would call Betty Levy. And Judge, if we could approach briefly.
Yes, I was just about to ask you to do that. Does anyone want to come up here? Yes, please. Rhodes.
That's correct, Judge.
And the Commonwealth has raised the issue of what is the relevance. I tend to agree that there's not a lot of relevance to that.
Judge, it specifically goes to both of the mental health experts just said that specific examples of behavior on the part of Mr. Rhodes would demonstrate paranoia.
Should.
Yes.
So why would you not have had the doctor speak with Ms. Nimi to see if that was in fact an example of something that could point to mental illness?
Literally, Judge, because Ms. Nimi would not speak to us about these matters. She's here under subpoena. That's why she's here.
Was there ever an attempt to have the doctor speak with her?
There's an attempt to have us speak with her.
That was my question.
I know, but she would talk to us.
I'm gonna ask you again, was there ever an attempt by the doctor to communicate with Ms. Nimi?
No, Judge.
Okay.
I don't,
Ms. Jones-Brown?
Judge, I mean, whatever is said, then we're gonna be arguing about whether the doctor would have taken that into consideration.
Yeah, I just don't, I don't see it.
the other aspect, Judge, is regardless of the doctor's knowledge, the court needs to be aware and have knowledge regarding the second prong of competency. The ability of Mr. Rhodes to rationally work with counsel is literally part of the definition, and he cannot. And the court needs to have that, we need to have that on the record.
He maybe cannot, he maybe chooses not to do so. But I don't think that Ms. Mimi is in a position to offer expert testimony about whether either of those things is true.
We're not calling her an expert judge, we're calling her to give facts for the court and for the record on the issue. And we believe that his ability or lack of ability to work with counsel goes directly to his competency to stand trial.
As to the first point that they wanted to limit this, I would ask the court not to limit it yet, because I don't know what would become relevant in cross. So I don't know what.
That is my other concern, is that it seems like counsel is saying you want to have her testify about Mr. Rhodes' interactions with defense counsel, but then what would be off limits?
Judge, under the rules of evidence, materials that are not intended as a confidential communication are not privileged. This is part of the reason why we were asking to seal the hearing, and I put in my motion that I believe that I had concerns that the court would have these questions, the Commonwealth would have these questions, which is why I wanted today's hearing to be closed.
And never at any point did the defense say, we're gonna call someone who worked as a mitigation specialist on this case.
She didn't work as a mitigation
What did
specialist.
she work as?
Counsel.
She was an attorney on this case?
That's correct.
That was never said either.
Well, Judge, in the motion, I said that we would.
So issues of attorney-client confidentiality could arise. It's very broad. So I guess what I'm asking you is what is it that you're trying to limit it to?
Judge, the communication about the case between Ms. Neely as an attorney and Mr. Rhodes is not what we want to ask her about. What we want to ask about is his actual ability to interact at all in a normal way with counsel.
Again, you're saying his ability. She does not have the expertise to say what he is able or not able to do, as opposed to it being a choice.
Well, but what you can do is testify about what actually happened. And those are facts, and that's evidence that we believe the court needs to have, and that the record needs to have in order to evaluate this question. Because, and Judge, I have often seen attorneys put evidence into the record when it comes to competency to stand trial, because of course one of the prongs of competency to stand trial is whether or not someone can.
I would be much more willing to agree with that if your expert had discussed this as a basis of their opinion in any fashion.
Well, he did, Judge. If you remember, Dr. Barkard just testified that part of his report, part of his conclusions were based on his information regarding Mr. Rhodes' interaction with counsel. He just said that.
And you also said he never spoke to Ms. Mimi.
That's correct. But Judge,
So then how could that have been a part of his consideration?
because of Mr. Rhodes' frankly incompetency, he has gone through multiple attorneys. So while the doctor has not spoken to Ms. Neely, he has spoken to other counsel. And Judge,
Why not call them if they're a basis of his opinion? I'm not inclined to allow it to give any other input.
No, but I would object to the putting into the record that he's gone through multiple attorneys because of his incompetency.
I certainly am not taking that as a fact. Mr. Griffiths is also not a mental health expert testifying in this trial. It's not evidence, obviously. I don't think it's relevant. You can step down. You are.
Judge, can you put
her evidence testimony inside out, we would move to put it inside out.
Your Honor, can I address, just from my perspective, all of my communications with Mr. Rhodes were covered and took place in an attorney-client privilege, which includes two parties, Mr. Rhodes and me. I do not intend to disclose any of my communications with Mr. Rhodes, including any observations I may have had about those communications. They're protected for his benefit, and I'm not going to put myself at peril for violating his rights and mine. And that's the reason I refuse to talk to them. And it's, had I been subpoenaed, a subpoena was taken to my front door. I came because
particularly in a situation where it's been made clear that Ms. Rhodes, I'm assuming, has not provided you with a waiver of the attorney-client privilege for Ms. Amy.
Mr. Rhodes won't speak to me, Judge.
Okay. Your excuse, Ms. Amy. A lot of people on that valley there, she's indicated she would not testify to anything because of attorney-client privileges.
Judge, I understand the court's moving for the record. We believe that our questions would have fallen under KRE 503, 5, and that they would not be matters that are covered by attorney-client privilege.
Yes, I know.
And what's going on here?
Do you want me to call over there and see what's going on?
They said it was in rounds. We'll take a review from Bill and see back over from this.
Anybody else? If we can just take a short break if you know.
We have more witnesses, Judge. Judge, we would call Jessica Buck.
All right. And is this for the same purpose?
It is, Judge.
Okay. Ms. Buck, come on up, I'll swear you, and then I'm gonna ask some preliminary questions. I also, this person wants you to acknowledge me. Yeah. Thank you, I'll turn right back to you. I also think that, it should at the least be put on the record that I have worked with all of these individuals in my private practice. I've retained Betty Mimi as a mitigation specialist on cases. You know, certainly I'm friendly with her, consider Ms. Buck a friend, and worked cases with her as well in my private practice. So this is something that I think most of you are aware of that, and all are aware of what I did prior to this, and that I also did capital work. So if there are any motions to be made about that, if you decide to make one, I'll make one. But I just want to get that out there on the record.
And Judge, just to because I don't think I put it on the record, and the court asked, of course I should have responded to that. The record does reflect that the prior witness, Ms. Mimi, was counsel in this case and was appointed by the court in the summer of 2016, and then filed the motion to be relieved, and was in fact relieved by the prior judge in early in 2017. And the court needs the dates, obviously they're in the court record, but I wanted to make sure that that was clear, just because you asked it, she is a mitigation specialist, so I wanted to
Yes,
clarify.
I understand, thank you. And she has the ability, this license to do that.
I also, any communications or observations that I had regarding Mr. Rhodes were during the course of my representation of Mr. Rhodes. I'm not aware that Mr. Rhodes has waived that confidentiality which belongs solely to him, and so I don't intend, and I've been very upfront with both counsel that I don't intend to answer any questions that I would prefer.
And let me be clear, I don't think counsel's done anything wrong by subpoenaing these witnesses. That is part of your duty to defend your client. But I'm not going to require an attorney to testify about matters they believe are covered by the attorney-client privilege.
Judge, then to
Especially without a waiver from their client.
Judge, this is this whole situation, as we talked about on Monday, there's no parallel. It's not like we can look to a similar case. We haven't had a similar case.
Mr. Rhodes our position is that he is not competent. And so when we're talking about things like a waiver, I think the issue of a waiver is better determined by the court in the circumstances of why we're calling a witness, rather than falling on that issue on Mr. Rhodes's desires in the case, because Mr. Rhodes is not competent to even execute a waiver. And I think this witness indicated to us that even if there was a waiver, she wasn't sure it would be valid because he's not competent, which of course is the catch.
There has been zero finding that Mr. Rhodes is incompetent. You can say it over and over, it doesn't make it any more true. There has been no finding of incompetence at all. I understand, please don't interrupt me. I understand your argument. I would be much more swayed by that argument if the court had been presented with any evidence whatsoever that these behaviors were a part of any opinion of incompetence. There's no evidence of that at all. There's no expert saying, yep, I knew about these behaviors and that goes towards my opinion.
But we do have experts who testified, including Commonwealth's expert, that if in fact there were specific incidents and evidence that would change his testimony regarding the existence of a serious mental illness.
May change his testimony, not would. And neither of those experts, as far as I'm aware, were provided with these examples that they very easily could have been provided with.
Dr. Garkar was provided with all of the examples.
And he did not testify that that meant that Mr. Rhodes was incompetent.
Well, Judge, when someone's mental condition gets in the way of completing an evaluation, that doesn't magically make them competent. It just means that we have to base the ruling on other evidence. And what I'm saying is we have other evidence. Both of the mental health experts said that other evidence would be something they would rely on. I'm just trying to get it before the court.
Could be. You're free to go, myself.
Judge, we would also move to introduce her testimony by avowal.
Again, Ms. Buck has stated that she would not answer questions based on the attorney-client privilege.
And Judge, we believe that all of our questions would fall under KRE 50385.
What I would suggest is that perhaps the defense could tender a list of questions they would have asked these witnesses. And then that can be maintained on the record.
I want to say it right there, Judge. That's not me saying I agree with
I know,
you.
I understand all of your objections stand and they're well taken.
Thank you, Judge.
Now, if you have other questions, great. If not, we can turn to the issue of the report being sealed or not sealed briefly while we're waiting for Mr. Rainey.
He may be on foot.
Okay. Okay, how can I get a status update? Should I call the jail?
No,
I have to walk over there with,
they're walking over, they're getting taken over.
okay.
If you want to take up the other matter, Judge, go ahead, Mark.
I've reviewed the competency report. There's nothing in it that is of a sensitive nature and wasn't already discussed in the hearing. So I am not going to seal it.
Thank you.
I will give the defense a chance to look at it and see if there are like particular parts you want redacted, but I think your position's gonna be no, we just think the whole thing should be sealed. Because there's no identifying information, there's nothing that wasn't already testified to in the hearing as far as I can tell. So before, I will on Monday unseal it.
Okay.
Short of hearing any reactions on that.
Thank you, Your Honor.
And Judge, just for my clarification probably, we're talking about the report that was completed in
The most recent.
most recent report.
Yes,
That's
it
the
is,
competency.
and it is dated January 4th, 2023.
tell the truth, nothing but the truth, not what's going on.
It's a yes or no, you swear to tell the truth and nothing but the truth.
If I have to, yeah.
Do you understand that if you do not tell the truth, you can be subject to perjury?
Perjury to what?
Saying something in court that is not true could subject you to perjury. Do you understand that?
Yeah.
Thank you.
Thank you, Your Honor. Could you please state your name for the record? And first, I would like to talk about how you know Brice Rhodes. Could you tell the court about your position in the jail?
Say it again.
Could you tell the court about your job at the jail as a lunch aide?
Yeah, I'm a work aide at the county jail.
And as part of that job, what do you do on a daily basis?
Serve people food.
And how did you come to interact with Mr. Rhodes?
I don't interact with him, besides drop his food off.
Okay, so you have dropped food off for Mr. Rhodes. And can you tell us what that looks like?
What do it look like?
Yeah, just tell us how you deliver those trays to Mr. Rhodes.
Door, open the door, get the food out of my hand and get it to him.
And while you were delivering those trays to Mr. Rhodes, where was he housed at that time?
Doorman.
And was he housed with other people? Or was he on his own?
What?
Was he housed with other people, or was he in solitary confinement?
It's all the same.
Okay, you're not sure. How often would you see him when you were delivering those trays?
How often would I see him? I don't see him often.
I understand that you might not see him anymore, but when you were delivering trays to him, would you see him every day?
Yeah. Whenever I serve food, I got to serve food, yeah.
And would you see him once a day, twice a day, how often?
Might be one time a day, and, you know, I wasn't working every day.
But you would see him frequently during that period of time.
I see him when I serve food, sometimes I do, sometimes I don't.
Okay, so let's talk about those interactions. Normally, when you serve a tray to an inmate, how do you pick the specific tray that you serve them?
I don't pick a specific tray, I grab a tray right in order.
Right, so the first one, the one that's next.
Right.
How about when you did it with Mr. Rhodes?
Same way.
So when you delivered the trays to Mr. Rhodes, you would just give him the first tray off the top.
Yeah.
And so your testimony today is that you would not allow him to choose his tray.
Lies, I'm not lying, I choose his own tray.
And when you were delivering his trays, was there ever a time when he got upset with you?
I mean, being in confinement, being, you know, I mean, everybody's upset, so, I mean, sometimes, sometimes not.
And was there an incident at Christmas time where there were some special food trays delivered that he got upset with you?
They wasn't special food trays, they was Christmas trays.
Okay, so Christmas trays. And so did he get upset with you at Christmas dinner?
We ended up having little words, I mean, you know.
What was that about? What was that about?
Trays?
Yeah, what was the problem with the trays?
I wouldn't let him look through, wouldn't let him look through the trays. I told him, that's your tray, you got to get your tray.
And what did he say to you?
I don't even remember what he said.
And did you let him pick his own tray?
Nah, I just went on and gave him the, you know, grab the tray, just grab the tray.
So is it your testimony today that that was the only time that he had an issue with the trays, or were there multiple times?
Nah, that was, I believe it could have been the only time. I go through a lot with, you know, just being there, so me remembering one incident, you know.
Time. No, you can't hear. I'm just saying.
If you could just speak a little louder, please.
At any point did he appear, or did he express any type of paranoia about the trays to you?
Nah, he ain't never talked to me about the trays.
Thank you, Council. Ms. Jones, do you have any other questions? All right, Mr. Rainey, you're here to go. Any other witnesses for the defense?
Your Honor, I'll call Ms.
What was the last name?
Henley,
Can you spell that?
P-E-N-U-D-L-E-Y, and she's an investigator on Brice Rhodes' case.
One more, I'll give us right here. So it's a truth and all truth? Thank you, Nancy.
Could you please state your name for the record?
Kristen Henley,
And what is your role on Mr. Rhodes' case?
the mitigation specialist.
And as part of your role in that position, did you come to interview Mr. Rico Rainey?
I did.
And can you tell the board about that interview that you did?
Yes, that was on January 13th, 2020. I'm sorry, I wrote the wrong year on my paper. And we spoke for.
I'm sorry, was it 2023?
It was 2023, I'm sorry, I just wrote the wrong date. I guess I hadn't realized that the year had changed yet. And we spoke for about an hour.
And during that conversation, did you speak about Mr. Rainey's position as the lunch aide at the jail?
We did. He was very hesitant to speak with me, said he didn't have any information for me. I explained, my role and why I was there, and we talked about just his interactions as a lunch aide with Brice.
And what did he tell you about his interactions as a lunch aide?
He told me that he did pass trays every day up until an incident that occurred at Christmas.
And was there anything particular about how he delivered trays that he talked to you about?
He said that he would pull them in on a cart, and that he would just take the next tray that was there, and hand it to the next person.
What about when he handed trays to Brice, to Mr. Rhodes?
He did tell me that he specifically would ask, like he would be like, no, I don't want that one that he was about to hand to him. I want, like he would point to a certain one.
And did Mr. Rainey give any more detail about why he would pick his own tray?
He did allude to me that he said that he thought that he was just paranoid and he didn't know why. He said that he would want a different tray because he thought that he was being poisoned.
And did Mr. Rainey tell you this was a frequent occurrence?
He said that he would usually point to a tray, and like say not the next one, he would point to a tray when he had the cart in front of him. And then on Christmas, he said that he had already handed him the tray, and Brice had already opened it and saw what was on it, and then tried to give it back.
And was there a reason that Mr. Rainey provided for him returning the tray?
Yeah, he said that he had already touched it, so he wasn't gonna give that tray then to someone else, and he couldn't waste the tray, so that's your tray.
And did Mr. Rainey tell you anything about Mr. Rhodes' reason for wanting a different tray?
I don't know that he told me a reason. I don't know that a reason was communicated to him. He just said that Mr. Rhodes was really upset about receiving the tray that he did, and he did not want that tray.
And did Mr. Rhodes make any statements at that time or accusations?
I don't know specifically. He was just upset.
Did you think that Rico was trying to poison him?
Yes, and Rico.
Objection.
Howard?
Can't know what, yeah, I was
You're right.
standing.
Was there anything else about that interaction that you recall?
After that, Mr. Rainey was was told not to pass trays to Mr. Rhodes anymore, and that the guards would pass to him specifically.
I have no further questions, Your Honor.
Thank you. Any questions? You're fine. You can go ahead and step down. Thank you. The other witnesses for the defense?
Judge, before, I'm anticipating the court's ruling on some of our witnesses. We have Warren Beck, who's available by Zoom. He is prior counsel to Mr. Rhodes. Is the court going to, does the court want him to sign in and be sworn?
I assume there's no waiver with Mr. Beck in place from Mr. Rhodes.
There's not.
The ruling will be the same. Again, I'll ask that the defense submit any questions they would have asked any of the prior counsel. The court is not allowing to be called as a witness. I'll review it. If I think that it very clearly stays away from matters covered by attorney-client privilege, then we will come back to it.
So Judge, do we need to have Mr. Beck appear by Zoom, or is this sufficient for that purpose?
I think this is sufficient, but any input from them? Yeah, okay, thank you.
We also had Scott Gravenstock, who was former defense counsel for Mr. Rhodes. Mr. Gravenstock was actually at a training this morning. He is under subpoena, but he said he would not be available. He's actually not available still for another till 1 in the afternoon, Judge. If that's going to be the court's ruling, however, I thought we'd send him a message that.
Yes, that will be the court's ruling.
Do we need to have him appear in person and be sworn or any of those things before that, Judge?
I would not require it.
I think the Commonwealth shook their head that they're not asking for anything.
Mr. Dravenstead had sent an email to the court staff this morning letting him know exactly the same thing Mr. Griffiths just said, that he was at a training out of town and would not be able to be here until later this afternoon. So if any of you have the ability to let him know that he's not going to be called today, that'd be great.
Okay. For the record, Judge, we believe that Mr. Beck and Mr. Gravenstock's testimony would have fallen under carry 503A5 and understand the court's previous ruling. We will include that in the tendered material which we submit to the court. Judge, I'm sorry.
No, you're fine, thank you.
And Judge, pursuant to Rule 3.7, it's a different rule, under the Supreme Court Rules 3.130, we would now ask the court to allow me to testify, questioned by Ms. Boyarsky. I feel strange saying to the
I
defense.
understand. I think we're gonna run into the same issue here, that there's not any kind of a waiver, and that it would be covered by attorney-client privilege. However, I would ask you if you could just to give the court an overview of what the expected testimony would be.
Judge, unlike the other attorneys who have stood before Your Honor this morning, I am not invoking attorney-client privilege. I understand the court. The court's ruling may be based on something else, but as the attorney, I'm not invoking attorney-client privilege at this time. Judge, I have a lot to say regarding evidence that goes to Mr. Rhodes' competency and my belief that he lacks that competency. My belief is not in question,
Judge, what I wished you to do was place on the record before the court incidents and evidence over my almost 6 years of representation of Mr. Rhodes that I believe are relevant to this very specific question of whether or not Mr. Rhodes is competent to stand trial.
I'm gonna again ask, are the things that you would testify, are those all things that were discussed with the defense's competency expert?
Yes.
Ms. Jones-Brown?
Judge, I object because the experts have already testified and are now, their testimony is over. And I believe the way this would have more properly come in is to say, here's some, did we discuss this? Did that affect your determination? Now it's just attorneys testifying to events that happened without the necessary medical analysis of how that affected their determination on the issue of competency. I mean, we already know that the defense expert opined that he was not competent. So this is all subsumed by that testimony.
Judge, if I may respond.
You may.
Judge, the ultimate determination is made by the court based on the evidence that's before the court. I believe that I have, and I'm not excited about it, Judge, just to be clear, I'm not excited about sitting in that chair up there, but I believe that I have evidence that the court needs to hear regarding Mr. Rhodes' ability to rationally participate in his own defense and do that along with counsel. Without that information, I believe the court may not be able to may not know the full picture. And I want the court to have the full picture. I want the court to have all the evidence before expanding the competency of Mr. Rhodes. I also believe that my testimony would fall under 503A5. If I could do that.
Explain to me how you think it falls under 503 as admissible.
Judge, what I intend to testify about are behaviors and not so much, I don't have 503 right in front. I have a feeling the court has 503 right in front of you. Yeah, it's in my book, Judge, but when they broke the law book into two, they messed it up for everybody. Judge, fundamentally, that rule of privilege deals with communications. And I believe that my testimony would not be about communications, and therefore would not fall under the attorney-client privilege.
Then what would it be about?
It would be about actions, Judge.
on the one hand, I think actions are very much like words. I mean, for piercing purposes, certainly a nod would be treated the same way as a verbal yes. However, given that one of the prongs of competence is the ability to rationally participate in one's defense, I certainly understand the reason that counsel wants to present this information to the court. I also do think that this is slightly different than the other witnesses because the proposed witness is standing here saying, I do not want to testify on anything that my client said to me. I think it's a very fine line though when you're talking about wanting to testify about behaviors as opposed to words and whether those are much different under the law. I also really don't want this to come back because of not allowing it. So Ms. Jones-Brown, what is the Commonwealth's objection to Mr. Griffith's testimony based upon?
It's, Judge, it is based upon the fact that Mr. Griffiths is not going to know whether it's the difference between ability or choice. That has to be filtered through the psychiatrist or psychologist. That information was made available to the defense expert, could have been made available to KCPC. The defense is allowed to send that information to consider. And to the extent that the defense expert took it into consideration, that is already on the record. That is something the court can already consider because that's been testified to.
Anything else from the defense in regards to this request to testify?
No, Judge.
I tend to agree. I think that if there had been other testimony from the expert about particular reliance on this, I would be closer to allowing it. But I also am very concerned without a waiver that we get awfully close to disclosing client communications without the client's waiver and agreement of the same. And again, you're welcome to submit something in writing after the hearing indicating what other counsel would have intended to ask you on the stand. But I'm not going to allow you to testify today.
I think the court anticipated, but we do object to that ruling, Judge.
Of course, absolutely.
Judge, it's the belief of the defense counsel that strange words come out of my mouth, Judge. I'm the last witness for the defense. The court having ruled that I'm not able to testify, that's all the witnesses that we have.
Thank you, Mr. Griffiths. I appreciate that. All right, are you all prepared to move into argument?
Yes.
Judge, it's our belief that the court should not rule until it reviews the document that you said we could submit to the court regarding the proposed questions. We would ask that the court review that and the information presented therein prior to ruling on competency. That would be our motion.
I appreciate that motion. I certainly understand it, but I am going to go forward today. If there's something contained in there that changes the court's opinion, then we will go from there, but I don't expect it to.
Judge, I guess formally I need to also offer my testimony as a proffer, even if the court doesn't want to hear it now in this manner.
Right, I'm just asking you to do that in writing.
Okay, so we should consider all of the attorney witnesses who
who did not testify, we
Should
should.
proper for them as well.
Better proper.
Yeah, in fact, when I wrote down tender questions, I was thinking that would include probably a proffer, so that would be fine. What the expected testimony would be.
Yes, Judge.
And I will also note that, you know, I'm not saying that this is in any way a substitute for having 4 or 5 witnesses testify as to the behaviors that I assume you're speaking of. But the court is also very aware, you know, of the number of, I've gone through the file very closely and very aware of the number of attorneys that have been on and then off of this case, and the reasons given by Mr. Rhodes and his behavior in court as well. So those are all things that I'm also considering. All right, Ms. Armstrong?
Your Honor, the Commonwealth does ask the court to find the defendant competent. As the court knows, the standard is that the defendant would be found incompetent if, as a result of a mental condition, the defendant has a lack of capacity to appreciate the nature and consequences of his actions or to participate rationally in his own defense. Everything that Dr. Allen discussed shows that he does have the capacity to appreciate the nature and consequences of the proceeding. He was coherent, he was of average to low average intelligence on the test that he took, where some of the tests showed that he was putting more low effort on his tests, and he was still getting those types of scores. He asked questions about the case, or about the court process, and made comments about the court process and about the past KCPC stay that shows that he had reviewed in some form the past competency evaluation or the criminal responsibility evaluation that Dr. Allen had produced. So the defendant was aware of that, and to the point of being able to comment upon it. He made comments about the court process that shows that he does understand what's going on. He understands the challenges that he faces because of having a high publicity case. Now, so the question is really going to be whether he can participate rationally in his own defense. And I acknowledge that there is just on the face of the court record a history showing that he has chosen not to participate with these defense attorneys of late. Now, other defense attorneys have left the case. Mr. McLeod represented in the district court, which chose not to represent in the circuit court. That was because of a conflict in as who the victims were. Then the PD's conflicted off because they represented the co-defendant. Mr. Dravensat was appointed off the conflict list. Ms. Neame was with him for a little while. He was removed from the case by his decision to take a job with our office, not because he left the case prior to that. And then it took a while to get new attorneys appointed because the whole public defender's office was conflicted off. And that's how we arrived here. But since, for several years at least, the defendant has openly in court expressed displeasure with his attorneys, asked for new attorneys, asked to represent himself, and in the end displayed clearly in court a refusal to communicate with these attorneys. So I'm not trying to make light of that. The question is that a decision that he's made, or is that something outside of his rational control where he cannot participate rationally with the defense? And unfortunately, we do have a lot of defendants in this court system who misunderstand the nature of the public defender system and think that these people are accused of the prosecutors because they all work for the state. So that's not an outlier, unfortunately, because we in the court system know that that is certainly far from the truth. But the fact remains that these are the attorneys he has, and he is allowed to choose not to work with them if he wants to, as long as he can, should And Dr. Allen has worked with him over 2 different ACPC stays, both longer than a month, the most recent one nearly 2 months. He has been able to observe him and communicate with his team, who observed him basically 24 hours a day over the course of these 2 stays. They watched him interact with peers, they watched him interact with other staff, they watched him function with his daily activities. They had conversations with him. There are psychologists, there are nurses, there are doctors, there's psychiatrists. They all have different conversations with him over the course of these months at KCPC. They do different testing, the psychological testing, physical tests, the psychiatric tests for the forensic tests for the competency to stand trial. And throughout that, Dr. Allen thought, based on scientific medical probability, that he's competent to stand trial, he's competent in both prongs, that he understands the nature and consequences of the proceeding, and that he could, if he chose to, participate rationally with his defense attorneys. He talked to Dr. Allen during the forensic evaluation. Dr. Allen believes that he would be able to make a coherent argument should he choose to testify, and that follows that he would be able to make a coherent argument to his attorneys about what direction he wanted this to take if he chose to. Just because he doesn't choose to does not then make him incompetent. The defense attorney, Dr. Agarkar, saw him for all of 5 minutes, and so he did not get the chance that Dr. Allen had and that Dr. Allen's staff had to see how does he interact outside of this one interaction. Because if he can interact and speak with peers, and he can interact and speak with the psychologist or the doctor, then he could interact and speak with his attorneys. And the fact that he does not, while he interacts with other people, shows that this is a choice. So the Commonwealth would ask the court, and just additionally, obviously, as the court knows, competency is about what's going on right now, not what's going on in the past. So any diagnosis he had in 2013 or in 2019, if it is not manifesting right now, would not affect his competency at this point. So we would ask the court to find that.
Thank you, Mr. Kaelin. Mr. Cummins.
Judge, as the court knows, competency to stand trial is a burden that the defense bears. It is, however, a low burden. It's by preponderance of the evidence under the Gabbard case. We believe we've met that today, even with just the evidence that's been presented before the court. The Commonwealth effectively just conceded that he is not rationally participating in his own defense. Their argument to the court was that it is not medically based. So there's really no question, as the court indicated, you looked through, there's years of record, but you've looked through it based on his actions, his pro se pleadings, Judge. They don't make much sense, but it's clear that he doesn't want his lawyers, will not work with his lawyers. His actions in the courtroom have demonstrated that he doesn't really understand his place or the role of the people in the courtroom. Even the fact that he continues to attempt to file motions when he's not a lawyer and doesn't know how to do it. As the court indicated to him, I think just in February of this year. He has run off multiple attorneys, Judge. It does not make him a competent person because I haven't quit him. He will not speak to me, as is in the record, and hasn't for years. He does not, and it's really not disputed, he does not participate rationally in his own defense. And that's where we are. That's the actual situation.
If you do nothing else.
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 If you do nothing else.